Good day and welcome to Apple Property Legal Update. Wian, I've got an interesting question for you. Please can you explain to me what is the difference between latent and patent defects and what does it have in your contracts and why should it be in a contract?
The difference between patent and latent defects are quite obvious. A patent defect is a defect that one should discover by normal investigations. Should one, for example, enter a house and a huge wall crack is clearly visible, that would be a patent defect. A latent defect, however, is something that is not visible with inspection. It's hidden from your view.
So basically, the Coetzer clause. Why must it be in an offer to purchase? So many clients lately come to us and say, but according to the new Consumer Protection Act, the Coetzer clause does not exist anymore or it should be taken out of the contract. What is your opinion about this? And should it still be in an offer to purchase or an OTP as we call it in the industry?
Traditionally, the all-encompassing Coetzer clause created a safety net for a seller when selling property or goods. This meant that the seller was indemnified against any defects, whether patent or latent in those goods, against actions from the buyer. The common law position were however amended by the introduction of the Consumer Protection Act in 2008. This act is however limited in its applicability or its ambits and when it deals with certain sale agreements. So certain sale agreements are expressly excluded from the Consumer Protection Act.
With latent and patent defects, I know you told us the difference, but can someone complain and where can they go to complain about latent and patent defects? And about which one of the two can they complain?
The effect of the Coetzer clause in a deed of sale is to protect the seller against all defects, as I stated previously, whether latent or patent. In the instance of patent defects, it is a all-encompassing, all-inclusive protection, and a buyer cannot come back to the seller claiming damages where a defect is classified as a patent defect. In the cases of a latent defect, there is not such a all-encompassing protection. The seller does have a certain responsibility in this regard. In the case of a latent defect, such protection is not all-encompassing. The seller has certain responsibilities and basically consisting of the following. Should the seller have known of a latent defect and deliberately hid the existence thereof from the buyer, the seller will be responsible to repair that defect. The problem, however, for the buyer is how to prove that the seller was indeed aware of that defect, the latent defect, and that he deliberately didn't disclose it to the buyer.